So let's start with a new chapter. Appointment and Qualifications of Directors. Section number 149 to section number 172. Read with the Company's Appointment and Qualifications of Directors Rules 2014. Division of chapter number 11. This is chapter 11 of the Companies Act. Totally there will be 4 parts. Basics and fundamentals for appointing a director. There we need to read following sections: 149(1), 162, 176 we left out, 165, 166, 153 to 159, 170 and 171, 152 subsection number 5. Part 2. Appointment related sections: 150 to 1 and 2, 160, 152 6 and 7, 161 subsection number 1 to subsection 4, 149 4 to 13, second proviso to section 149 1, section 149 3, section 151 and 163, 164, 167, 168, 169 exits of directors. Part 4 miscellaneous, 172 and its analysis, section number 152 3 and 4. These are the various areas. So total chapter will be divided into 4 parts. These are the 4 different parts in which the total chapter is divided. So it starts with part number 1, basics and fundamentals, ends with the miscellaneous part number 4. Write down this in the notes first. First you need to have the learning objectives. What are the concepts? At the end of this particular chapter, all the tick marks should be there, like what is there when you see the screen. Recent completed bachelor, we have done that. This handwritten notes was there. Every point we have covered. Okay. Right now. 1 second. So keep the heading. Qualifications and appointment of directors. Qualifications and appointment of directors. Okay. Section 149 to section 149 to 173. Sorry, 172. Section 149 to 172. Branch it into 4 parts. Branch into 4 parts. Part 1. Basics and fundamentals for appointment. Basics and fundamentals for appointment. Part 2. Appointment related sections. Appointment related sections. Part 3. Exits of director. Exits of director. Part 4 miscellaneous. So write down all the parts and the sections inside. Completed writing? First two parts completed? Completed? So there are totally 4 parts in the chapter. So part number 1 will be fundamentals for the appointment. Part number 2 will be talking about appointment related. 3 will be on the exits. 4th will be on the miscellaneous side. Okay. So today we are first going to complete the basics and fundamentals. Okay. In this session we will be concentrating completely on basics and fundamentals for the appointment of a director. Okay. Once we complete and the next session we will start with the appointment related sections. Okay, fundamentals will take some time because there are so many sections, not just one. Starting from section 149, subsection number 1 to 162, 176, 165, 166, 153, 4, 5, 6, 7, 8, 9 DIN provisions, 170, 71 and 152, 5. Substantially good number of sections will be there inside the fundamentals with regard to the director's concept. Therefore, take some time. Today's session don't expect more than fundamentals to complete. Clear everyone? Once that is completed, from the next session onwards we start with the appointment related sections. I told you in 50% of the time what we given for the board meeting, this will be completed. That's for sure. Clear or not everyone? Board meetings and board powers, whatever time it has taken, in half the time we complete the directors. That's for sure. So concepts are simple, crisp, but logically more strong and logically more sound than the board meetings chapter. And when it comes to the interpretation, this is a more times difficult than the board chapter. If you feel that, that is okay. If you feel that the previous one, the board meetings and board powers, is interpretation wise fantastic, this is a 4x. Did you understand? So it will be times bigger than that. Okay, so when it comes to the logical interpretation, it is more sound and strong than the board meetings chapter. So let's see. Board meetings chapter, so many procedural sections are there. Video conferencing, okay, video conferencing, quorum procedure, or register under 187, register under 189, okay, contracts with one person company. Like this, so many procedural compliances are also there, along with the more logical interpretative sections. But here, fundamentals, if you read, section 153 to 159, could you see that? 153 to 159. That is the only procedural section in the entire area. Next one is section 170. Next, immediately after that. So, if there is any procedural type section in director's concept, that will be only 2 area. Number 1, DIN, 153 to 159. Number 2 will be 170 and 171 registers again. Registers for the director's concept. Clear everyone? So let us try to understand every point in detail. Let's start with the fundamentals. Keep the heading. Basics and fundamentals with respect to appointment, part 1. Basics and fundamentals with respect to appointment. Okay, na? Clear? Okay. So listen carefully. Part number 1, basics and fundamentals with respect to the appointment. This is how the concepts will be dealt with. You need not write everything inside the notes like this. but summary we need to write on each and every section at the end. Okay, so let us first go into the Bail Act. See here, company to have board of directors is the name of the section. So we started with the chapter. Please, everyone, please see the screen. So what is the first section we are going to start with? 149. Section start with 149, ends with 172. So first section is 149. So the basic charging provision we need to understand first before we start with anything, right? So let's start with the concept. See there, what is the topic name? Company to have board of directors. This section 149 will be having 13 subsections inside. Okay, 13 subsections will be there inside this particular area. Biggest one in the entire directors chapter. In this area called as directors, the biggest section is the first section. What is the first section? 149. Okay, therefore 149 section we will not read in one go. We will divide this total 149 section into 4 parts. Okay, 149.1 and 149.2 will be talking about basics of directors appointment. 149.3 Indian resident director. 149 subsection 4 to 149 subsection number 13 independent director. Second proviso to 149.1 women director. That means total 149 section we will break into how many parts? 4. Basics, women director, Indian resident director, independent director. We will break this section into how many parts? 4 parts. One point being 149.1 and 149.2 we will read here. Okay, next session appointment of directors time we will read women director, Indian resident director, independent director concepts. Clear everyone in the class? In the same sequence. See here, what is the sequence in which we are going to study? See there, analysis on 149, analysis on 149.1 and 149.2. 149.2. Immediately after this analysis, we will go to which section? 162. After 162, 176 left out concept. Next one, 152 subsection number 5. After that, 165. After that, 166. After that, 170 and 171. Like that, our sequence will be completely different from the sequence whatever we have written there. Okay, in a correct logical sequence we will be going on with this chapter. So please see the screen, everyone. Analysis on section number 149.1 and 149.2. Concept dealt. See here, what we are going to read in this 149, total 149 we are not going to study. I am repeating once again. We are reading what? 149.1 and 149.2. Sir, when we are going to read the remaining? See here, that's what I have shown you. Basics are completed. Read now. What is the part 2? Part 2 rasara akkada. Appointment related sections and rasara. Sections list you have written. Read the first section. 152 subsection number. That's the first director. Next. 160 right of a person to stand for directorship other than retiring director. Next one. Rotational, non-rotational director. Next one. 161, 1 to 4. Additional director, alternate director, nominee director, casual vacancy director. Next. 4 to 13, independent director. Next. Women director. Next. 3, Indian resident director. Next. 151 and 163, small shareholders and proportional representation. Next. Managing director, whole time director, and tribunal appointed. Just for the list sake I have written. Concepts of separate chapter are there. MD, WTD are covered in separate chapter or not, everyone? In that chapter we will read. Tribunal appointed director we will read in prevention of oppression mismanagement. Okay. Last 3 are for understanding sake. Remaining are covered in this chapter. Now, did you understand the concept? So, total 149 we are not going to read today. 149 la what part we are going to read now? 149.1 and 149.2 we are going to cover now. Okay. Now, in 149.1 also, second proviso we are not going to read again, because second proviso is covering women director concept. When we come to women director concept, we will cover those. Clear? So, in the sequence which is correct to read, in the same sequence we are going to study. So, let us start with the part number 2. What is the part number 2, sir? Appointment, part number 1, fundamentals and the basics for the appointment of director. What is the first section we are going to start? 149.1 and 149.2. See there. Concept dealt. What is the first one? Minimum number of directors. Next one, maximum number of directors. Next one, procedure to increase beyond maximum. Next one, transitory provision. Last one, other points inside. So let us see what are all these. Let's start reading the Bayre Act. 149, subsection number 1. Start. Every company shall have a board of directors consisting of individuals as directors, and shall have a minimum number of 3 directors in case of a public company, 2 directors in case of a private company, 1 director in case of a one-person company, and a maximum of 15 directors, provided that a company may appoint more than 15 directors after passing a special resolution. Stop there. Read once. Start ending a Bayre Act. Be very careful. Completed? First thing, tell me, what is the capacity to become a director? Individual. Minimum directors in case of a public company, private, OPC, maximum in all cases 15. Can we have more than 15 directors? General limit is 15. Clear or not, everyone? General limit is 15, not the total limit beyond which company cannot go. Like that he didn't tell. Generally, there should be some limit. That limit is 15. Beyond 15 also can we go or not? Okay. That means if you want to appoint more than 15 directors, you can do that only by passing which resolution? Clearly he said special resolution. Here we need to pass a special resolution, increase the limit. Clear, everyone? Sorry. Now listen carefully to the logic. In my company, there are how many directors? 15 directors. I want to appoint Mr. A and Mr. B. 2 directors, sir. Clear or not, everyone? Okay. Now I'll answer my question clearly. I want to appoint how many directors? 2 directors. Tell me. In my company existing, how many? I want to add how many? 2 directors. This 15 appointment requires a special resolution, not requiring a special resolution. Under this section, required or not required? Not required. Requirement is there only for within 15, above 15. Okay. Appointment of next to 2 directors, A and B, requires which resolution? Everyone answer. Like this, you should not think. I can start in the Sajata Chon, sir. Read there. A company may appoint more than, first incident, provided that a company may appoint more than after passing a special resolution, not bypassing. Bypassing allowed. Akkada sayata chadukondi sare. After passing a special resolution, bypassing. ఏముంటుంది సార్ డిఫరెన్స్? రెండు ఒకటే కదా సార్? రెండు ఒకటేనా? అవునా? Both are not same. Why both are not same? బాలబాబు చెప్పాడని కాదు, అర్థమైంది, వినపడింది. సో why both are not same, let us try to understand clearly. Okay, see here, tell me, in the example in my company existing, how many directors are there? 15. I want to appoint how many? You said that this appointment requires which resolution? Wrong. This requires a special resolution. Means what? Tell me. Okay, first number is 15. Number is 15. Directly 2 can be appointed. First we need to add this should come first. After this should come. Okay, so technically to understand what he want to tell, director is a chair. This is a chair of a director. Clear? 15 chairs are there already. Imagine like that. 15 chairs la 15 are sitting. You will make directors to stand? No. First we need to arrange the chairs and thereafter we will call them, or first we will call them and later after some time we will arrange the chairs. That arranging a chairs is covered by this section, not the appointment. Adding 2 chairs requires special resolution. Read the section content clearly. After adding the chairs, how many are there totally? How many chairs are there now? How many I want to add? Answer, sir. Can I keep that chairs empty after adding them? Yes, sir. Read the section carefully. Provided that a company shall appoint or may appoint. Asal appointment mandatory kaadu. This section is not talking about appointment of more than 15. Increase the limit beyond 15 is discussed in this section. You can appoint in future. This section is not talking about appointment of directors beyond 15. Increasing the limit beyond 15 is discussed in the section. Clear or not, everyone? 15 plus 2 la 2 requires special resolution, plus requires special resolution. That addition requires special resolution, not the appointment. And moreover, do you know one important thing? Maybe you don't know. Let me explain this. In the example, we are adding how many places? Answer, sir. A, B, 2 persons are appointed, right? See here. We want to appoint A as a additional director. We want to appoint A as a additional director. And we want to appoint B as a independent director. B as a independent director. Additional director requires board of directors approval. Independent director requires ordinary resolution approval. Then why you are passing special resolution? Therefore, this resolution is not for appointment. This resolution is for increase. Sir, after increase you will appoint. First you will appoint and after increase. Ante a company may appoint more than 15 directors bypassing after passing. After passing which resolution? What will be done using that special resolution? Additions will be made. What will be made, sir? Additions will be made. First 2 spaces will be created through 149. In those 2 spaces, 2 directors may sit now or maybe in the future. This section is not talking about appointment. This section is talking about increasing the number beyond 15. So tell me, maximum general limit is, can I go beyond 15? Yes. How? క్వశ్చన్స్ ఆత వినండి సార్, ఏది పడితే అది ఆన్సర్ చెప్పి ఇక్కడ నోటుకు వచ్చింది. వినండి ఇంకోసారి. ఏ కంపెనీ ఈస్ హ్యావింగ్ హౌ మెనీ 15 directors. Okay, I want to increase the limit beyond 15. I want to increase limit beyond 15. What I have to do? After passing bypassing bypassing appointment should be after passing. Word appoint వచ్చినప్పుడు after రావాలి. Really the increase requires special resolution only. Increase will be made by special resolution. Appointment is made after passing special resolution. Did you understand the concept, everyone? అందుకే ఈ లోకంలో ఉండండి సార్ అని చెప్పా. నేను ముందు ప్రికాషనరీగా చెప్పకుండా స్మోకింగ్ ఈజ్ ఇంజూరియస్ టు హెల్త్ అని స్టార్ట్ చేయండి సినిమాస్లో. మీరు పట్టించుకోవట్లేదు అంతే. సో ఐ విల్ గివ్ ద డిస్క్లైమర్ ఎవ్రీ చాప్టర్, ఎవ్రీ వర్డ్ బిగినింగ్. లిసన్ కేర్ఫుల్లీ, దిస్ ఈజ్ మోర్ కాంప్లికేటెడ్ అని బిగినింగ్ లైన్లోనే పేలిపోయింది. ఇక్కడ ఉండండి లోకంలో. సో ఫస్ట్ పాయింట్, ఇన్ మై కంపెనీ హౌ మెనీ డైరెక్టర్స్ ఆర్ దేర్ ఎగ్జిస్ట్? 15 directors. How many places I want to increase? 2. Making total as? Increase will be made after passing resolution. Increase will be made by passing a special resolution. By passing a special resolution, you will first increase. Clear now? Now tell me from the appointment point of view. Appointment will be made after passing a special resolution to increase the limit. Adi varu cheppadalchukunna section lo. That's what you want to convey. Clear or not everyone in the class? So first, what is I want to appoint. From the appointment point of view, if you see how to tell that, appointment you should make only after passing a special resolution. That means that special resolution is passed for what? Increase in the limit, creating extra places. Once the place is created, after that only you can appoint. Appointment is optional or mandatory? Optional or mandatory? Sir, in my company there are 15 directors already. No intention to appoint in the near future in 1 month or 2 months or 5 months. But I want to increase the limit to 18. Can I? Yes, you can do that. You can do that. Yeah, contingency. You can create and leave. Clear or not everyone? Suddenly you want 2-3 appointments. Immediately you can appoint them in the spaces. Rather than at that time again going for special resolution. Okay. So this is appointment addition. Resolution is to increase, resolution is to appoint. Now tell me, I want to increase limit by another 3. By passing yes sir, after passing yes sir? I want to appoint 3. Adi what appointment point of view lo dani comprehend cheskuntu vachadu section ni. He comprehended everything from the appointment point of view. Now everyone read the section. A company shall have a board of directors consisting of logic, sir. Why individuals only? Not decision making. Sir, answer my question. Sir, sir. Can artificial person type of entity can become the director? Why? డెసిషన్ మేకింగ్ ఏవో చెప్తున్నారు కదా, ఏదో ఉందిగా, మీకు ఒక ఐడియా ఉంటుందిగా. ఓకే సరే, ఏంటిది? బాడీ కార్పొరేట్, షేర్ హోల్డర్స్, చైర్లో కూర్చోలేదా? వెరీ గుడ్, వెరీ గుడ్. ఇట్ కాన్ సిట్ ఇన్ ద చైర్. బాడీ కార్పొరేట్ కాన్ సిట్ ఇన్ ద చైర్. ఓకే, హూ సెడ్ దట్ ఆన్సర్? నువ్వా? అయితే నీకే క్వశ్చన్. దెన్ బాడీ కార్పొరేట్ కెన్ సిట్ ఇన్ ఆడిటర్స్ చైరా? LLP కెన్ బి ఆడిటర్. ఎస్ సార్, నో. కెన్ LLP ఆఫ్ ఆడిటర్స్ కెన్ బి ఆడిటర్స్ ఆఫ్ ఎ కంపెనీ? వాళ్ళు కూర్చుంటున్నారు చైర్లో. ఏ కుర్చీ తెచ్చుకుంటున్నాడు? అంతే కదా. నా ఆన్సర్ వీల్ చైరా? Sir, anyway, the main answer is, sir, listen. నోటి దాకా వచ్చింది ఒకటి, క్లాస్ రూమ్ అని అయిపోయా. వచ్చేసేది కొంచెం ఉంటే, ఇక్కడ దాకా వచ్చింది. సరే ఎందుకులే, క్లాస్ రికార్డ్ కూడా అవుతుంది కదా అని చెప్పి అయిపోయింది అంతే. క్లాస్ బయటికి రా ఒకసారి. సో సరే, లిసన్ కేర్ఫుల్లీ టు ద పాయింట్. సో ద మెయిన్ లాజిక్ ఈస్, directors can't be other than individuals is a logic. Okay, sir, we will give an answer saying that sir, they should be accountable, etc, etc. We will tell lot of answers. My only question is, why artificial person can become auditors? Because liability ఉండదా ఆడిటర్లకి? అసలు ఫస్ట్ లైబిలిటీ ఏమైనా ఉంటుందంటే ప్రపంచంలో ఎవరికైనా అది ఆడిటర్కే. ఫస్ట్ లైబుల్ పర్సన్ for all financial frauds in a company. Recently ICAI released a notification, do you know or not? Arresting the chartered accountants for all reason. మరి ఎంతకన్నా క్లాసిక్ ఎగ్జాంపుల్ ఏముంది లైబిలిటీకి? ఫస్ట్ లైబుల్ పర్సన్సే చార్టర్డ్ అకౌంటెంట్స్. సో ఆన్సర్ నౌ. ఇప్పుడు దాని గురించి మీరు చర్చా వేదిక పెట్టకండి, ఎవడెవడు అరెస్ట్ అయ్యాడు, ఎందుకు అరెస్ట్ అయ్యాడని. ఆన్సర్: ఆర్టిఫిషియల్ పర్సన్ కెన్ బికమ్ ఏ ఆడిటర్, బట్ ఆర్టిఫిషియల్ పర్సన్ కాంట్ బికమ్ ఏ డైరెక్టర్. Something unusual. If you tell artificial person should be accountable, decision making, etc., then auditor should also be only natural person, individual. Why firm LLPs are also allowed? Why LLP of directors is not allowed? Kada. So this question has to be answered. Okay? And now listen carefully. So the point is, company is an artificial person or natural person? Answer, sir. Company is like a car. Artificial person. It can't move on its own, including Tesla. దాని అంతా అది ఆపరేట్ అవ్వదు. కనీసం ఇంజిన్ ఆన్ చేయడానికైనా ఒక మాన్యువల్ పర్సన్ కావాలి. ఓకే, ఆ తర్వాత అది ఏం చేస్తుందని పక్కన పెట్టేసేయండి. ఆఫ్టర్ దట్ వాట్ ఇట్ విల్ డూ ఇస్ ఎంటైర్లీ డిఫరెంట్ స్టోరీ. ఈవెన్ ఇన్ కేస్ ఆఫ్ టెస్లా కార్, సమ్ మాన్యువల్ ఇంటర్వెన్షన్ ఈస్ రిక్వైర్డ్ అట్లీస్ట్ టు ఇగ్నైట్ ద ఇంజిన్. A remote control or normal thing, anything, some manual intervention is required. Clear or not, everyone? Automatically, if you want to on it, that timer also should be fixed by a human being only. Automatically nothing will come. So company is like a car. Listen carefully, I am not just taking an example for foundation level. Really it is helpful for you to understand. Listen, company is a artificial person like a car. Clear? Now answer my question clearly. Car lo 2 seats will be there in front. One is the ICAl seat and the one is the driver seat. Take for example. Now listen carefully. Director is like a driver. All the others are on the back seat or front seat, etc., other than the driver seat. Clear, everyone? And now listen carefully to the logic. I will put a mobile phone in the other than driver seat. Driver is sitting here, I am a driver. This was kept in the other side of the seat. Will the car move or not? Answer, sir, everyone. Yes or no? Now listen carefully to the point. Now I will sit on the other side and I will put this mobile phone on the driver's seat. Will it move or will not move? Endukani? Company ki directors are like a drivers. That must be an artificial person. Natural person. Once a natural person sit as a driver, remaining can be anyone who can sit on the other side of the car to move that. Directors are the drivers of the company. Clear, everyone? If the company is a car, directors are drivers, auditors are like the other seat. That person can be artificial person or natural person. Use me dustbin, if you keep on the other side of the driver seat also, the car will move. But the same use me dustbin can't drive the car. Technically, to understand in a simple words, artificial person cannot direct another artificial person. Artificial person can't drive another artificial person. A car can't drive another car. Did you understand what I said? One natural person is required to control the driving seat, and that natural person in Companies Act will be directors. Directors must and should be the natural persons, being individuals only. One person should be readily accountable. Problem that comes with the directors is, if you tell company can be a director of another company, company la portions will be there now. There will be lakhs of shareholders. So many directors. If X Limited can be director of Y Limited, X Limited is a director of Y Limited, X Limited does some wrong, then who should be made accountable? 1 lakh shareholders will be accountable. Therefore, problem will come with the accountability issue. Therefore, lawmaker has clearly said that in case of a company, driving seat should be taken only by a natural person, being directors, being individuals. After that, any person can have any capacity in the company, like auditors being artificial persons. LLP is artificial person, natural person. Separate legal entity with an artificial existence or not, everyone. It can become auditor because you are not in the driving seat. You are not directing the company. You are just a reporting person. You can be anyone. Persons who drive the company must be only the natural persons is the logic of this section. Clear, sir, everyone in the class? Okay. Now answer my question. What is the capacity to become a director? Everyone. Firm, body corporate, AOP, BY, society, cooperative society, companies, body corporates can become the directors? No. Next, minimum directors in case of public, private, OPC, maximum in all cases. Reason of 3 to 1 also I already discussed in the board meetings area. So here we can save the time. So next, can I appoint more than 15 directors? Can I appoint more than 15 directors? How? Yes, now it is the answer. After passing a special resolution. That special resolution is for what? Increasing the limit beyond 15. That means the first step number 1 is increase the limit beyond 15 by passing a. Second step, after passing SR, you may appoint the directors in the vacancies. Clear or not, sir, everyone in the class? This is how the section has been drafted. So hope everyone understood subsection number 1, clause A, clause B and the first proviso. Clear, everyone in the class? Now very, very important concept which institute like so much. Articles involvement into this section. Okay, let us see what it is. Already we have seen one point. Can articles give more strictness of the provisions? Can it relax the existing one? Kada, common sense use change sir koncham. Please everyone be attentive, listen carefully. Tell me, public company let us take. What is the minimum number of directors in a public company? 3. Maximum? Act said minimum 3. Act said maximum 15. Articles cannot go below the minimum. Articles can't go beyond the maximum. Beyond the maximum you can go only with the permit of 149 provision. Whatever we read now, SR we have to pass. Directly can we write in articles 18, 20, 25, 30? No. By following what we can do that? Procedure set out in first proviso to section number 149(1) only we can do that. Section numbers are mandatory to write in examination. మీరు రాయని ప్రతి సెక్షన్ కి హాఫ్ మార్క్ తీసేస్తుంటాడు వాడు. జాగ్రత్త, CA ఫైనల్ ఎగ్జామినేషన్స్ లో సెక్షన్ నెంబర్స్ రాయకపోతే మార్కులు పోతాయి. If you don't write the numbers on the sections, you will lose the marks. Half mark పోతూ ఉంటుంది రాయని ప్రతి చోట. So please listen carefully. That's why I use it to always repeat the section numbers. I repeat once again. First proviso to section 149(1), okay, says that you may appoint more than 15 directors. That means can directly in the articles can I write 18, 20, 25, 30 like that can I write? No. At the time of incorporation, what is the maximum I can write in the articles? 15. Can I write directly 18? No. That means at the time of incorporation, the number can't go beyond. Number can't go beyond 15. Company gets incorporated. 2-3 years after, I want to increase it to 18. Directly can I alter the articles and write 18? No. You have to alter articles anyway. But first you need to take whose permission? Shareholders' permission. Bypassing a. For appointment or for increasing a. Correspondingly alter the articles as well. How that will be done, I am going to explain now. Clear? Very, very litigant concept. కొంచెం వెరైటీగా ఉంటుంది ఇది. కొంచెం జాగ్రత్త వినండి. Please listen carefully. Because we need to read section 14 with section 149. What and what? 14 with 149. 14 is alteration of articles. 149 is increasing the limit. రెండు కలిపి చదువుకోవాలి. So please listen carefully. We have to read combinedly. See that. What is the minimum directors in the act? అక్కడ రాసిందే అడుగుతున్నా మిమ్మల్ని. What is the minimum directors under the act for public? Maximum? That means can I have between 3 to 15? Directly without altering articles anything. Can I have or not? Now tell me, you said me minimum 3. That means minimum 3. Can I have more than minimum? Maximum 15. Can I have less than maximum? Now tell me, can AOA provide in this company that minimum should be 5, maximum should be 12? Valida, not valida? Valida, not valida? Valida, not valida? 100% valid. 100% valid. Act is a silent, na articles can interfere. Act lo how much is the minimum? నేనే 3 అని చెప్పినప్పుడు ఓవర్ యాక్షన్ వద్దు. 2, 1 అని రాసుకొని. Maximum is don't write 18, 19 directly without compliance of the section. In between, chance was given to the companies. 3 is the minimum, 15 is the maximum. ఈ మధ్యలో మీరు ఏం చేస్తారు, మీరు చావండి అన్నాడు. That means in a company, in the articles, can I write minimum is not 3, minimum is 5? Can I write like that or not? So many cooks spoil the dish laga. I don't want to make it 15. I want to restrict it to 12 for a better decision making. Can I do like that or not? Yes. That means, tell me. I will ask you the questions, answer one by one. Articles can, minimum side in Japan. Minimum side. Articles cannot provide for. 4 క్వశ్చన్ అడగబోతున్నాం మళ్ళీ ఈ లోకల్లో ఉండండి ఫస్ట్. ఓకే, ఆర్టికల్స్ కెనాట్ ప్రొవైడ్ ఫర్ లోవర్ మినిమం అంటారు దాన్ని. ఓకే, లోవర్ మినిమం, హయ్యర్ మినిమం, లోవర్ మినిమం, లోవర్ మాక్సిమం, హయ్యర్ మాక్సిమం, లైక్ దట్. ఓకే, టెల్ మీ ఆర్టికల్స్ కెనాట్ ప్రొవైడ్ ఫర్, ఆర్టికల్స్ కెన్ ప్రొవైడ్ ఫర్ higher minimum. Okay, next one from the maximum side. Articles cannot provide for, articles can provide for. That's all. This is the 4 answers. So now tell me from the minimum maximum point of view, tell me articles can provide for higher minimum, articles can provide for lower maximum, articles cannot provide for lower minimum, article directly cannot provide for higher maximum. If you want to provide for a higher maximum, procedure has to be completed and then alter the articles. Clear or not, sir, everyone in the class? So articles of association can interfere means yes, without deviating the act you can interfere. 3 అనేదాన్ని బ్రీచ్ చేయకు, 15 ని బ్రీచ్ చేయకు. Without breaching 3 and 15 you can do whatever you want. Clear everyone? Okay, now listen carefully. Special resolution under section first proviso to section 149(1) is for what? Increase limit beyond 15. Okay sir, నేను దాని గురించి అడగట్లా. That increase the limit beyond 15 for what? For altering the article, sir. ఏంటి అసలు అదే ఆ రెజల్యూషన్ దేనికి? ఇంక్రీజ్ బియాండ్ 15. ఓకే, ఇంక్రీజ్ బియాండ్ 15 ఇన్ ద ఆర్టికల్సా? అది డౌట్ అంటే అర్థమైందా? సో ఈ బ్లాంక్ ఫేస్ ఎగ్జామినేషన్ హాల్లో ఉండకూడదు అనేది నా ప్రయత్నం. సో ఇలాంటి డౌట్లన్నీ క్లాస్లో వస్తే చాలా బాగుంటాయి, అది వింటే గుర్తుంటాయి. ఇఫ్ యూ లిసన్ యూ విల్ రిమెంబర్ దిస్. Confusing concept in the exam, the most confusing area is interpretation of articles with this section is the most confusing one. So let me explain clearly. You can solve any exam question once we done this. See here, the point is very clear, sir. 149 subsection number 1 la which resolution is required to increase? That special resolution is not for altering the articles. That special resolution is taking the permission of shareholders, informing them that we are going to increase the limit beyond 15. Increase. Now check your articles. Example, so many situations will come now. Listen carefully one by one. See here, I will write here. Please see here now. AOA provided for 10. Actually, company is having 6 directors. Company want to increase by another 2. Procedure required. Chappan. 149 first proviso will get attracted. Alteration of articles will get attracted. Nothing will get attracted. Okay, if you want to increase, okay, alteration is required. Just if you want to appoint to, nothing is required directly. Anyway 6 is there, 4 remaining places are there. Appointment don't require anything. But if you want to increase what? 2, already how much is provided by articles? Answer, sir, everyone. You want to increase by how much? Ikkada jaata vinandi, sir. Company want to increase. Sir, tell me, company want to appoint to. What is the requirement? Is there any section to comply? No. Directly you can make your appointment depending on the resolution. Okay. Now my question is changing. Please listen carefully. Take same example now. How many is provided by the articles? Actually, how many are there? I want to increase further to not appointment now. I want to increase by another 2. Now tell me 10 want to be made as how much? Now 149 1 will be attracted or not attracted? Attracted or not attracted? 149 gets attracted for alteration of articles or for increase beyond 15. 15 is crossed or not crossed? Now tell me 149 1 compliance required or not required? That's all. It requires only what? AOA alteration. Simply section number 14 will get attracted. Which resolution we need to pass? Special resolution. That's all. This is the answer. Clear, everyone? First case, everyone understood? What is the moral of the story in the first case? We want to increase within the 15 but beyond the articles. Within but beyond. Very good. Now listen to the query. Second question. AOA provided for 12. First chapter, this is valid or not valid? Providing for 12 in articles. Valid. Okay. Actually in the company 12 are there. I want to add 3. Procedure. I want to add 3. Procedure. Alteration required or not required? Section number? Very good. Next one. AOA provided for 15. Nothing you provide now, 15 will be default. Nothing you provide, 15 will be default. Okay. AOA 15. Actually 15. I want to add 2. Tell me. Section 14 attracted, 149 gets attracted. Both gets attracted because 149 is not for alteration. 14 is not for shareholders approval. Shareholders approval to increase the limit is taken under which section? Later alteration of the articles will be made under which section? So 149 should be read along with 14. Understood the concepts, everyone in the class? Very, very important compliance. So see here, in this case, we are going beyond 15 or not? Articles provided for? When articles are standing at 15, shareholders gave permission of 2. Suddenly, if it goes to 17, still articles it will be 15 only, which should not happen. Therefore, both are 2 different approvals. 149 is a specific permission for increase. 14 is for alteration of articles. 14 is for in the same general meeting they will pass both the resolutions. If any one resolution is not passed, matter cannot take impact. First they will tell the shareholder, dear shareholders of the company, our company existing is having 12 directors or 15 directors. There is a need for nominee directors. We are going to add 2 directors. So please give your approval with regard to the increasing the limit beyond 15, and we also seek your approval for alteration of articles to make necessary arrangements. Like that they will pass how many special resolutions now? 2. 1 SR is for increase anagandi sir, increase deniki, whose permission you are taking? Shareholders permission. For what? Increasing the limit beyond 15. You take whose permission? Shareholders. Under which section? Later that particular you have taken the permission. Now with that permission you will alter the articles. For that again which resolution is required? Special resolution. Everyone understood the concept clearly? So then what is the difference between that SR and this SR? That SR is a permission taking section. This SR along with the altered articles you need to file with ROC. File with ఎందుకు? ఎందుకంటే నీ ఎంసీఏ మాస్టర్ డేటాలో రిఫ్లెక్ట్ అవ్వదు వాడి పర్మిషన్ తీసుకుంటే. ఇంకా వెళ్ళగల ఎంసీఏలో మాస్టర్ డేటా ఉంటుందా? మాస్టర్ డేటాలో 15 should be shown, 17 should be shown. How 17 will come if you don't tell anything to ROC? Now did you understand the concept, everyone? You have taken permission, okay. Articles like it should be reflected with 15 or 17 or 17. Who should register articles? Therefore, alter the articles. Alteration of articles is a mandatory. Remember always. 15 దాటింది అంటే ఫస్ట్ ఆల్టరేషన్ దేనికి? Alteration of articles is required. Now further. So answer. I have so many questions to ask. Answer these and then only we will go into the next one. AOA 12. Actual 12. Increase 4. Chapman. Exactly same question was asked for 4 marks in the latest exam, not in the previous. The previous. ఈ ముందు కాక ముందు ఎగ్జామ్ మొన్న జరిగింది కాక ముందు. Okay. Tell me what is the answer. How many directors are already there? 12. Actually how many are there? 12. AOA provided for 12. Actually also 12 are there. First tell me, can articles provide for a lower maximum? Yes, therefore it provided for 12. Now they want to appoint how many directors? Directly can they appoint? First what they have to do? First what they have to do? Increase. How the increase will be done? That you need to tell now. First you should take whose approval? Shareholders approval. వాడు అప్రూవల్ ఇవ్వకుండా ఆల్టరేషన్ ఎందుకు వెళ్తున్నావు? ఆల్టరేషన్ మొత్తం చేసే డబ్బులన్నీ కట్టేసినా వాడు వద్దంటాడు. After paying everything to the ROC for the fees to alter the articles, shareholders shall know. Then money will be wasted kada. Therefore think positively. Read Companies Act at the corrections. First you need to take whose approval? Under which section? To increase the limit beyond. To increase the limit beyond 15. So you want to make an increase beyond 15 kada. For that you need to take the permission. Clear? They passed a yes sir. They passed a yes sir. They have consented positively for the increase beyond 15. Okay. Now 149(1) proviso approval is obtained. Later they have given permission. Now in the articles 12 is visible or 16 is visible? Now I want to change the 12 to 16 or not. For that what is required now? Alteration is required. Under which section? 14. As per section 14, which resolution we need to pass? For making the 12 to 16 and file it with the ROC. ROC will do the registration and reflect that in the MCA website. How did you understand the concepts, everyone? Clear, everyone in the class? Okay. This is the question, sir. So this is how the scenarios can come. Hope everyone in the class understood the section clearly, right? So see here. Impact of articles on section 149. Just normal notes for understanding. Read. As per section 5, MOA shall contain regulations for internal AOA shall contain regulations for the internal management of the company. As per section 5, AOA shall be in a format specified under schedule 1. That's called as a table F. Sir, I am not making you to write all these things because already we completed that in the board meetings area. Already I told you about the model articles, table F, everything is completed or not? All the modalities inside that already we have cleared. Read. Next one, as per section 5, AOA may provide for additional matters. Had we completed this or not? Yes. Next one, as per section 6, contents of AOA cannot run contrary with that of the act. Did I tell this point also or not? We have already written this, therefore you need not write again. Any provision in the articles which is contrary to the act shall be declared as void. Therefore, on a conjoined reading of section 5, 6 with 149 1B, we can draw the following conclusions. Okay, read. Particulars. Lower minimum? No. Higher minimum? Lower maximum? Higher maximum? No, but subject to the proviso, you can take the permission and do that. Directly you can't do. Clear or not, everyone? As per section 14, alteration of articles required which resolution? So hope everyone understood the point as well, right? Okay, see the notes now. Minimum and maximum directors. Public company, private, OPC, maximum in all cases. Procedure to increase the limit beyond 15. A company may appoint more than 15 directors after passing a special resolution. Read. Under the proviso, increase in number of directors beyond 15 requires a SR. That means SR is required for increase beyond 15 but not for appointments beyond 15. Impact of AOA, exemptions and transitory provision. Sir, hope everyone understood up to what we discussed. Clear? See here, sir. One important point. This has no relevance today. See, there in the syllabus, let me just discuss. Whatever the point I am going to discuss now is there in the Bare Act. Will never be asked in exam. These sections are called as a transitory provision. What is a transitory provision? From the old Companies Act, it came for temporary purposes and again went back. But still there in the Bare Act, now let me discuss. Please see the screen. So tell me how many number of directors are allowed maximum generally? In the old Companies Act, there is no such concept on limit on directors. You can have 20, you can have 25 directors also. Clear, everyone? Tell me. When the new Companies Act has come, 2013. Let us say, dates not required, 2013. Okay, now listen carefully. Before 2013, my company is having 21 directors. How many, sir? 21 directors. Allowed as per old Companies Act? Yes, allowed. Suddenly, which act came? 2013 Companies Act have come. Clear? Now, in the 2013 Act, what is the maximum limit? 21 or 15? So, excess how many are there? Chapale. Now tell me, 6 are in excess of the statutory limit provided by the new Companies Act or not? You should pass a special resolution under this section taking the approval of shareholders for the excess 6 within 1 year from the date of commencement of this act. From the date of commencement of this act. They have given due date actually up to 31/3/2015. That means by 31/3/2015 you should pass which resolution? Special resolution. For how many directors increase? 6 directors increase. If you could not pass, 6 directors office shall be deemed to have vacated. Clear? MCA will remove randomly 6 directors names from the master data. Okay, so much serious. Once upon a time it used to be. Now this compliance must be completed by which date? First insurance, sir. Under the old Companies Act, there is a limit on directors or no limit, sir? Can I have 21 directors? Yes, my company is having 21 directors. Suddenly, which Companies Act came? In the new Companies Act, what is mandatory? 15 beyond requires a SR. Shareholders approval is required. Clear or not, everyone? Shareholders approval is anyway required beyond 15. But previously, there is no such approval required. Therefore, what law has said is, you have to pass a special resolution for the excess 6. But immediately you need not pass. By the end of which date? 31/3/2015 you can pass a SR. 31/3/2015 has been completed 7 years back. Yes or no? Therefore, when this section came itself, this question is not asked in exam. So 7 years back only this concept is over. Just for the sake of concept you read. Technically there is no validity for this answer. Sir, where is this? Subsection 2. Read. Every company existing on or before the date of commencement of this act shall within 1 year from the date of such commencement comply with the requirements of provisions of subsection 1. So how many years time was given? 1 year. Technically they closed it on 31/3/2015. Up to there they have given the real time. With the, before that time you need to pass a special resolution. Now that is having validity or no validity? No validity because that has completed 7 years back. Okay. With this we completed the first part of our fundamentals with regard to the director's appointment. See here, learning objectives you have written. What is the first area you have written? 149.1, 149.2. Had we completed? Write down the notes. Write down one by one. Point number 1. Keep the heading company to have board of directors 149.1 and 149.2. Company to have board of directors 149.1 and 149.2. Okay, na? 149.1 and 149.2. Write down one by one. Point number 1. I will ask the question, answer and write. What is the capacity to become capacity to become director? Write down. Only individuals can be directors. Point 1. Only individuals can be directors. Only individuals can be director. Okay, va? Completed. Second point. Minimum and maximum directors. Minimum and maximum directors. Minimum and maximum directors. Minimum and maximum directors. Write this. Completed. Minimum maximum directors. Write down this. Procedure to increase limit beyond 15. Notes you need not write. Write only up to after passing a special resolution. Remaining everything will be there in the material I gave. Analysis notes, everything. Completed? Completed writing, everyone? Okay. Next, keep the heading illustrations. This is important for the class. I will give you questions, you answer them. We will go to the next section. So that question, why requirement? I will show you some exam questions directly. Answer those. See here. So this is a compilation on appointment and qualification of directors. Okay. Appointment and qualification of directors. Totally past 40 examination questions I compiled. 40 examinations. So directors, how many questions are there? Let us check. I didn't include the last 2 attempts paper. I have to accept those. How many questions are there totally? 122 past exam questions are compiled. Take another mock test, RTP, all these recent ones. If I add 10 questions, will I get added on this? Sir, 130 questions totally. Only on what? Directors. Totally 846 questions will be there. From the past 40 past examination questions answered as per the relevant provisions and relevant Companies Act on amendments. Okay. So we are into the first area now. See how the answer has to be written in the examination. So many people are having the doubts. See, in the question bank, I have clearly reflected the answer. First, I will give the summary in the question bank as well. What are all the sections? Okay, let's solve this question now. To what extent you understand? Let's check directly how the questions will come in examination. Sir, if at all a question is repeated, I will give like this clearly. When it is asked, 2003 November, 2003 November. In the brackets, what is there? Means that is as per the old act, limit is not there. At that time, the question is there. I made small modifications to that. Next, when this question is asked, 2009 June 2009 elections time. June lo padinappudu. So 2009 elections time. So therefore it was conducted in the June 2009 exam. This was asked like the same question. So this was asked in May 2010 and this is asked in not in exam, RTP November 2015 question like that. So this question is a study material question. This is all how it makes. So each and every question, this is from CS final December 2001, 21 years back. A question was asked in CS final examination. One very good question to understand the validity of that particular section. So anyway, it's a compilation of CA, CMA and CS examination questions. Past 40 attempts we have taken. Foreign company, government company chapter, when the question bank comes, you can see 1988 onwards we started those. So whatever the questions they asked at that time, now they are repeating once again. Previously in the company law question paper, 1995 exam November one question is asked, same was repeated again. So they are not taking the recent RTP and mock test in exam, they are taking the very old ones, 25 years back, 30 years back questions, they are digging and getting back and giving into the new provisions. So anyway, let us see this question, try to answer. Number of directors appointed by each of the following companies is 9. Sir, why sir he has given each of the following companies? The provision what we read now, they are having some exemptions. Which companies are having exemptions? Let us see first. Sir, what are the provisions we read till now? Section numbers tell me. 149 1. Next, first proviso to 149 1. Next, 149 2. Okay. See the exemptions that were given and tell me in case of section 8 company, section 149 1 and the first proviso to section 149 1 shall apply or shall not apply? What is the meaning? Tell me. In case of section 8 company, 149 1 and proviso do not apply. What is the meaning? In 149 1 what is said? Minimum, maximum, increase the limit beyond maximum. This is what discussed in 1 and 2. Clear? That is applicable or not applicable? Means, can a section company have lesser than 3? Answer. Can it have more than 15 directly? Yes, that is the meaning. But that is a wrong interpretation because minimum directors is common for every company in India. Yes or no? You can't start a section company with 1 director. Therefore, government released this notification by mistake. It would have released as section 149 subsection 1 clause B. But what is missing here? B is missing there. Therefore, 2017 year, Nalika Kurukuna director, MCA, they have given another notification on the same. What they have done, let's check. They have released yet another notification saying the following. See here. For entry number 8, in exceptions, etc., section 149 1 and first proviso shall not apply. The following shall be substituted. What shall be substituted? Clause B and first proviso. That means in case of section 8 company, what does not apply? In case of section 8 company, what does not apply? Total 149 does not apply. 149 1 clause B only does not apply. Clause B will be talking about total directors minimum, maximum. When maximum does not apply, procedure to increase beyond maximum also will not apply. Therefore, needless to say that proviso do not apply. You need not tell that clearly. Okay. So that's one exemption that was given. See the third footnote and read. In case of company, section 149, subsection 1, clause B, and the first proviso shall not apply. First proviso shall not apply. Tell me, what does it mean again, everyone? What is 149 1B? What is the proviso to 149 1? Both are applicable for government company or do not apply. What does it mean now? What is the meaning? In case of a government company, minimum number of directors will be 3, but the maximum can be beyond 15. But increasing beyond 15 requires the procedures under 149, not required. That is the idea behind. Everyone understood the concept clearly? Minimum is the only requirement. So tell me, summarize and tell me, which companies are outside the purview of compliance procedure? Section 8 company and a government company. Both the sections, minimum applicable or not applicable? Maximum applicable or not applicable? When maximum is not applicable, procedure to increase beyond maximum has no sense. Clear, everyone? Now read the exam question and answer now. Read. The number of directors appointed by each of the following companies is 9. Okay. ABS Company Limited. Chapali. Public ka private? Very good. DSP Trading Private Limited. Public ka private? Exemption given for private, public ka? No. Exemption given only to which company? అందుకే వాడు CD పాయింట్స్ యాడ్ చేశాడు. చూడండి అక్కడ కింద ఏముందో చదవండి. Traders Association, a company registered under Section 8 of the Companies Act 2013. Okay, next one. Hindustan Paper Limited. Hindustan Paper Limited. Which company? Government company. The board of directors of the company wants to increase the number of directors to 15. State whether with reference to the provisions of Companies Act 2013, whether the directors can do so. Question 1. What would be your answer if the number of directors is proposed to be increased to 16 instead of 15? Read it. Okay na? Answer now. First thing, in examination question comes like this for 5 marks. This is a 5 marks question. How we will present this? First thing, this is the manner in which we need to write. Marks ko icha jodne ela chestadu vadu. See there. What we have to write? First one, point of law. Tell me. మీరు యాక్ట్లో ఏముందో రాయకుండా డైరెక్ట్ కంక్లూజన్ రాయండి. నాది గ్యారంటీ మీకు హాఫ్ మార్కులు పోతాయి. 4 మార్క్స్కి ఇచ్చిన 3 మార్క్స్కి ఇచ్చిన ఫస్ట్ యూ నీడ్ టు రైట్ ద ప్రొవిజన్. లా పాయింట్ రాస్తే ఫస్ట్ యూ విల్ గెట్ హాఫ్ ద మార్క్స్. ఆన్సర్ మే బి రాంగ్, బట్ అట్లీస్ట్ ఫర్ ద లా యూ రైట్, యూ విల్ గెట్ ద 2 మార్క్స్ 1 మార్క్ హాఫ్ మార్క్ సంథింగ్ యూ విల్ గెట్. ఓకే, మీరు డైరెక్ట్లీ కేస్ ఇఫ్ యూ మెర్జ్ విత్ ది సెక్షన్, ఆటోమేటికల్లీ ఐ కాంట్ గివ్ సపరేట్ మార్క్స్ ఫర్ ది కేస్, ఐ కాంట్ గివ్ సపరేట్ మార్క్స్ ఫర్ ద సెక్షన్ యూ రైట్. దెర్ఫోర్ ఎంటైర్ థింగ్ విల్ గో రాంగ్. First write down law. Even if your conclusion is wrong, for the law you have written, they will give the marks. Read. First one, point of law. How to write? As per section 149, 141, every company shall have individuals as board of directors. Second one, minimum directors you need to write public, private, OPC. Next, in all cases, all kinds of companies, maximum permitted number of directors shall be 15. Next, a company may appoint more than 15 directors after passing a special resolution. Next, maximum directors and procedure to increase beyond maximum shall apply or shall not apply or shall not apply to Section 8 company and government company. That's a common condition I told you. In order to give any exemption to Section 8 company, private company, etc., they should not be defaulted in filing financial statements and annual returns. You write the section first. For the section you write, they will give marks like this: half, 5 halves, 2.5 marks. For your conclusion, the remaining. Children, sir. Analysis of the given case. Sir, he is asking increase up to 15, increase beyond 15, both. Question chadivara sir anta safe itta screen మీద. He is asking two questions there. Number one, up to 15. Second one, 15 to 16. That means he is asking both the questions or not. Now answer. In case of which company? ABS Company Limited. Public, private, OPC, Section 8, government. Applicable or not applicable? Tell me the procedure. If I want to increase up to 15, 149 requires a compliance or no compliance? Okay, read. Since maximum permitted number of directors shall be 15, increase from 9 to 15 doesn't require any additional legal compliances. Did he tell anything that article provided for 12? Kabatti, this is the answer. If he would have given in the question articles is 12, what you have to do? Alter the articles to increase from 12 to 15. Clear? Next. If increase it to 16, what to do? Read. Since maximum permitted number of directors shall be 15, any increase beyond 15 shall require a special resolution. Like that you need to write. Traders Association. Next one is also same. Traders Association Section 8 Company. In case of Section 8 Company, provisions relating to the banks and directors and procedure to increase beyond maximum shall not apply. Thus, a Section 8 Company need not pass a special resolution to increase the number of directors beyond 15. Same answer even in case of Hindustan Paper Limited. Which company? Government company. Clear everyone in the class? Okay, very good. Next, read this question. Second type of question he can ask in exam can be in this way. I want you to read the latest one. 2015 Ladigan question. Articles of Association of a Survey Private Company. First, private limited companies are applied with the section or not applied? Applied. Provided that maximum number of directors in the company shall be how much? 15. Presently, the company is having how many directors? 12. The board of directors of the said company decide to increase the number of directors to how much? 16. Advise whether the provisions, whatever they can do. Read the question once. Okay, na? So tell me, articles provided, okay, maximum directors as per the articles is how much? Now in my company, how many are there actually? Next, I want to increase from what to what? 12 to 16. Okay, now first tell me 149, one compliance, first proviso of compliance, required or not required? First, we need to pass a special resolution to take the permission from the shareholder to increase the limit beyond to 16. Later, we need to pass a special resolution again to alter the articles and make the 15 to 16. And we need to file that altered articles along with the special resolution with the ROC for the compliance and making the necessary changes. Hope everyone understood the answer clearly. Remaining everything is same. That's how the answers will be. Okay. ఒక్కసారి ఇక్కడ చూడండి సార్. రీడ్. KMR Limited, a listed public company. Which company? Listed public company has 15 directors on its board. The articles of association of said company provide for maximum number of directors in the company to be 15. Due to diversification and expansion activities, the board of directors of the said company desire to increase the number of directors to how much? 18. Decide with reference to the applicable provisions of Companies Act 2013 whether board of directors can do so. Will your answer be different if the said company would have been a government company? Next, what if KMR Limited was formed for prompting the girls' education with 15 directors in its board? Due to expansion of its objective at large scale, the company increased the strength of its directors to 20 without passing a SR. Directly they increase it to 20 without passing SR. Valid or not valid? Valid. Girls Education represents a Section 8 company. మీకు ఇంకా అర్థం కాలేదు నేను తయారు చేసిన క్వశ్చన్ KMR అని నేనే అది ఎగ్జామ్లో అడగల నేను అడగదలుచుకుంటే ఇలా అడుగుతా క్వశ్చన్ ఒకసారి చూపిద్దాను ఎలా ఉంటాయో ఇప్పుడే క్వశ్చన్ చదివారు కాబట్టి కనీసం ఇన్ ద క్లాస్ ఆఫ్ 80 or 90 వాట్ ఎవర్ ద కేస్ మేబీ సమ్ పీపుల్ కుడ్ అండర్స్టాండ్ దట్ సెక్షన్ 8. ఆఫ్టర్ ఎవ్రీథింగ్ కంపెనీస్ యాక్ట్ కంప్లీషన్ వెన్ దే గో టు ఎగ్జామినేషన్ 20 వితౌట్ పాసింగ్ ఎస్ఆర్. హీ సెడ్ ఎస్ఆర్ ఈజ్ మ్యాండేటరీ. సెక్షన్ 8 కంపెనీ అని అడిగితేనే మీరు రాస్తారు, కానీ నేను అడగను క్వశ్చన్ ఎగ్జామ్లో. ఐ లాస్ట్ క్వశ్చన్ లైక్ దిస్, నో వేర్ ఐ విల్ స్పెసిఫై సెక్షన్ 8. క్లియర్ ఎవ్రీవన్? ఇలా ఉంటుంది సార్ క్వశ్చన్. ఏంటయ్యా చేయరుగా? దెర్ ఈస్ నో సచ్ థింగ్ దట్ కెన్ హ్యాపెన్. ప్రాంప్టింగ్ ద గర్ల్స్ ఎడ్యుకేషన్ అన్నా, అండ్ నాట్ ఫర్ నార్మల్ ఎడ్యుకేషన్ సిస్టమ్. సో ఇట్ ఈస్ ఓన్లీ ఫర్ ఎంపవర్మెంట్ ఆఫ్ ద గర్ల్స్. దట్స్ ద ఐడియా బిహైండ్ దిస్. So only to prompt the girls' education, we have done like this. In such a case, this becomes a Section 8 company, and the directors of that particular company can increase the limit beyond anything without passing any kind of special resolution. If it is a normal school, I would have written school there clearly. Okay. So anyway, everyone understood how the remaining question, I think everyone understood. Articles provided for how many? Actually also how many? 15 are there. First, if it is a general company, 2 sections will get attracted. What are the 2 sections? First proviso to section 149(1) and section number 14 squarely gets attracted, will comply. Government company la no need to increase the limit beyond 15 procedure. This is a section company, then also not required. So this is how the questions will be. And in adiged okay question, everyone understood the logic clearly? Okay, write down the illustration. 1 or 2 illustrations you do, I will give. First, let me write down. Three cases I will give. Listen first. See here, maximum provided by article says 12, 14, 15. Actually there in the company 10, 14, 15. Proposal to appoint 2 directors. Proposal to increase by 1, proposal to increase by 2, four. Tell me the procedure now. First case, what is the maximum provided by AOA? How many actual are there? I want to appoint how many? Which resolution is required? Nothing is required. You can make a direct appointment. Procedure I will tell you, you can write later. Okay. Next, how many are provided as per the AOA? How many are actually there? I want to appoint, I want to increase. Increase how many? Which compliance is required? Which compliance is required? 149 required or not required? Why? It is not going beyond 15. So only articles has to be amended in this case. Hope everyone understood, right? Okay, next issue. Next one. Maximum how much is provided by articles? 15. Actually also how many are there? Now proposal to increase to, what is the procedure? First one is 149(1) plus section number 14. How many SRs are required? 2 SR. 1 SR is for permission of shareholders to go beyond 15. 1 SR is for alteration of articles to make the number 15 to 16. 16 or 17 or 17. Next, 12 to 16 procedure. Procedure same or different? Same as point number 3. Write down, sir. You don't copy all the 4 in one set. First write down one procedure answer, next 2 3 4 like that, or else space constraint may come. Write down case number 1. First copy down the case 1. Write down in the procedure. Procedure. What is the procedure? What is the procedure? Is there any procedure involved? I don't. No procedure involved. Directly a company can appoint. No procedure involved. Directly the company can appoint. Next one. Second one. 14 increase by 1. First proviso to 149(1), section 14. Write down. Alter AOA under section 14. Alter AOA under section 14 by SR. Alter AOA under section 14 by SR. Okay, na? Next, number 3. 15 increase by 2. 15 increase by 2. Next one also copy down, flower bracket and write both. Both have a common answer now. Don't write anything, just tell me one logic. What are the sections we need to comply with? First proviso to section 149(1) plus section 14. Right now. First proviso to section 149(1) plus section 14. In the brackets write down 2 SR. 2 SRs. That means how many resolutions we have to pass? 2 special resolutions we need to pass. Clear as said everyone in the class? Completed up to here? Okay. So we now completed successfully the first part of section number 149. So 149 subsection number 1 proviso and subsection number 2 is completed with this. Up to here everyone has the clarity, yeah? Everyone in the class? Okay, next. So we now completed 149 subsection number 1. 1 and 2 completed. Next section in the learning objectives. Go there. What is the next section? Please tick in your learning objectives, section 149. Write down the heading. Section 162. Appointment of directors to be voted individually. Section 162. Appointment of directors to be voted individually. Section 162. Section 162. What is the topic, sir, everyone? Appointment of directors to be voted individually. Section number 162. So let's read. Sir, everyone. Sir, attention to the section, everyone, please. Let's read. Appointment of directors to be voted individually. Sir, first section we already completed. From here, lot of speed will come in the answers as well. Small sections. Let's complete off. Appointment of directors to be voted individually. Read the section. At a general meeting of a company, a motion for the appointment. Sir, in terms of Companies Act, the term motion represents before passing a resolution is called as a motion representing a resolution. Okay. Anyway, continue. At a general meeting of a company, a motion for the appointment of 2 or more persons as a directors of the company by a single resolution shall not be moved unless a proposal to move such a motion has been first agreed to at the meeting without any vote being cast against it. A resolution moved in contravention of subsection 1 shall be void whether or not any objection was taken when it was moved. A motion for approving a person for appointment or for nominating a person for appointment of director shall be treated as a motion for his appointment. So let us see what does it mean. Please read the section for a while. Subsection 3 we are not going to discuss now. Another section will come. 1 and 2 we will complete here. Please read those. And those are only asked in exam till date. This is a very important section for the exam as well. Multiple times tested. Please read subsection 1 and subsection 2. Clear? Shall we continue? So why this particular section would have come? Maybe everyone understood at least to some extent. Every director must be elected only by a independent and individual confidence of public. 2 persons or more than 2 persons who should not stand in a batch and get one side appointment. Everyone please see here. So the point is very clear. Batch appointments are prohibited at law. Sir, okay, idea is clear, but still logic of the section is still ununderstandable. See here, I will give you 1 or 2 examples. In the coming elections for the central, we said like this. I want to make Narendra Modi and Rahul Gandhi to stand in a batch. Never it happens in the history of India politics. Example sake, superficially let us consider like that. One will be for the PM candidature, another one will be for the HM candidature. Let's say for example. Okay. So now listen carefully. This is the scenario. Government announced it like this. Narendra Modi and Rahul Gandhi will be appointed by a single resolution or a single vote. Means what? I will explain. Narendra Modi, Rahul Gandhi, 2 persons are there. 2 persons having like-minded, repelling-minded. Totally 2 are on the 2 different sides. Motive different, concept different, ideology different. Everything is different. I am not talking about any positives and negative attributes of both of them. I am just telling both are negative side persons totally. One thinking and another thinking is totally different. Clear? This is a scenario. So the point is, A person is there. Our bro spouse is there. That person, during the election time, he saw this. He saw that the candidature is having Narendra Modi and Rahul Gandhi. He saw the candidature and thought, I vote for Narendra Modi. But if Narendra Modi, if I vote, automatically Rahul Gandhi will also come. Okay, I don't like Rahul Gandhi. If I don't vote for him, it is equal that I didn't vote even for Narendra Modi. Did you understand the point, everyone? A person like Modi, he will vote for whom? But automatically who will also come along with him? A person don't like Rahul Gandhi, therefore he don't want to vote for that. Immediately who also you are missing? Like this it should not happen. Batch appointments, this is a problem. Election of one becoming the election of the another. Rejection of one becoming the rejection of another. Clear or not, everyone? Clear, everyone? Another person is there. Another person like Rahul Gandhi but don't like Narendra Modi. That person, sorry, I want to vote for Rahul Gandhi. He voted for Rahul Gandhi. Automatically who will also come along with him? Narendra Modi. If I see Narendra Modi and said that I don't want this person and I don't elect, automatically I am missing a chance also to vote for Rahul Gandhi. Like that it should not happen. Companies Act also is not an exception for that. Directors of the company can't be elected in a batch. Every director must be appointed by a separate resolutions. Batch appointments are prohibited by Companies Act. Clear, everyone in the class? However, anything can happen in Law and Companies Act. Therefore, exceptions are there. Anything can happen. Politics lo kudardemo gani, corporates lo matram kudurutundi. There is a small exception that was provided as a rider, as a proviso. So let us try to understand what is the rider that they provided for this section. What they said is something similar to this. Please see here. I want to elect G1 and G2, B1 and B2, G1 and B1. See here. Good and good, bad and bad, good with a bad. Three situations can occur. Clear, everyone? Okay. Good with a good, equally good, better good. Okay. Bad with bad. One is bad, another one is a dad. Like that category persons. And third category, one is good, another one is very bad. Third category. Okay. Let's see now. Sir, understand with some common sense. Nothing beyond that is required. Good and good standard for the election. Good and good are standing for the election. Now answer. They are good in the opinion of everyone in that sitting in this particular room. Clear or not, everyone? Now answer. Please. If G1 stands independently, will you elect her, will not elect her? Hope that he is good for everyone. Okay. If he stand independently, will you elect or not? If G2 stands independently, will you elect him or not? Then what is wrong in electing both of them by a single resolution? Clear or not, everyone? Now the question arises, sir, what is the proof that they are good? That is the asal point. Therefore, law said like this. Do one thing. First thing is proposal resolution. In resolution, proposal resolution. Second one is appointment resolution. నేను మళ్ళీ రిపీట్ చేసి ఇంకోసారి వినండి. First one is a proposal resolution. Second one is a appointment resolution. Proposal resolution is a resolution where the idea of the board of directors to make two persons to stand in a batch must be approved by a unanimous approval in the general meeting. చదివారా in the section? ఏం approval? Unanimous. All the votes should be casted in favor without even a single vote cast against it. మీరు ఏం చదివారు కానీ ఇంకొకసారి చదువుకోండి సార్. చదివి ఓకే అన్నాక I will tell you the point. Sir, here the word, the motion represents a proposal before a resolution is passed. So anyway, read it. I want you to read only subsection 1. 2 also not required. Read only 1 first. Okay, na? Can I continue? Have you read the section, everyone? And now let me continue this. See here now. First thing, whenever you want to appoint 2 directors by a single resolution, sir, 2 persons stand in a batch. To make them to stand in a batch, 1 resolution is required. అసలు బ్యాచ్గా నుంచో పెట్టచ్చా అనే ఐడియాకి ఫస్ట్ అప్రూవ్ చేయి. దట్ మీన్స్ ద ఐడియా టు మేక్ 2 people to stand in a batch must be first agreed to at the meeting without even a single vote being cast against it. Clear or not, everyone? Without even a single vote cast against it. Means first thing is your idea to make 2 persons to stand in a batch must be agreed by the meeting without even a single vote cast against it. That means if for example there are 100 persons here, clear or not, everyone? 100 persons are there, 99 only participated, 1 didn't participate. Did you understand the point, sir, everyone? How many are there? 100 lo how many participated? 99 only participated, 1 person didn't participate, he abstained from the meeting. But the all other 99 has approved to it. Now this is approved or not yet approved? Do you remember the unanimous approval we read in the board powers concept? 12 directors are there. In that only 8 attended. In that 9 or 10 attended. In that 10, 1 person is abstained. Remaining 9 participated. But participated 9 voted in favor. Resolution passed or not passed? Passed or not passed? దేవుడికి తెలియాలి అసలు మీరు ఏం విన్నారో. 186 section when we read, I said clearly unanimous approval of all the directors present. 12 directors la 10 are present, 10 la 1 abstained from voting, only 9 participated, 9 la 9 voted in favor. Resolution passed or not passed means not passed. Because all the directors present should participate, all the participants should vote only in favor. That is the logic of the section. Had I told you or not already? Likewise, here what I am asking is, general meeting is there, 100 persons attended, 99 only participated, 1 abstained from voting. But this 99 voted in favor. That is enough. Yes, that is enough here. Enough here. Without even a single vote cast against it. That means those who participated in casting the votes only we should count. 100 la 10 didn't participate, leave them. How many are participated in casting the voting? 90 should cast in favor. We need to take only those who casted the voting should cast in favor. Wordings are very important. మీరు అది వదిలేసి చదువుకుంటున్నారు ఇంత జరిగాక కూడా, ఇన్ని క్లాసులు అయ్యాక. So after so many classes also you are reading the same. Read. At a general meeting of a company, a motion for the appointment of 2 or more directors of a company by single resolution shall not be moved unless say proposal to move such a motion has been first agreed to at the meeting without any vote being cast against it. That means first what should be there? Casting the votes. We need to count how many votes are casted. In that casted votes, not even a single vote should be coming against it. Means what? Every vote casted should come in favor. Ante whom we should take? Present, participated and voted. That is the first question. On this no question was tested till now. If at all it has to be tested on this area, they will test in the next exams. ఈ casted, present, abstained మీద అడుగుతాడు. Clear everyone? Understood the logic clearly? Okay, next issue. Not yet completed. We are just in the beginning. Read down. First issue. Sir, how many directors we want to make stand in the batch? In this example, 2. Now, can I directly make them to stand? No. First, what resolution? Proposal resolution. What is a proposal resolution? Your proposal to move a resolution to appoint 2 directors by a single resolution. That means you want to get the approval for idea to appoint 2 directors by a single resolution. Idea to appoint 2 directors by a single resolution. Shareholders has to first approve that without even a single vote cast against it. They have to approve that. Now scenario see there. First example. Who are the 2 persons you have taken? Good and good. Good with bad. Bad with bad combination. Good with a good combination. Now we made 2 persons to stand in a batch. Okay. Shareholders saw both of them. He is G1, he is G2. Anyway, I want to appoint him. Anyway, I want to appoint also him. Okay. What you are trying to do? We want to appoint both of them by a single resolution. Okay. Okay, we will approve. No, you should not approve like that. First, approval of idea, okay, or proposal to make these 2 people to stand in a match. First, approve that. Every shareholder raise the hand. They raise the hand. After that, which resolution will be kept? Second resolution will be appointment resolution. Which resolution? One ordinary resolution is passed. Both will get appointed. How many? One ordinary resolution is passed. Both will get appointed. Everyone understood? Come to the second category. See the second one. Second one. Good with good, bad with bad. B1, B2 stood in a batch. Shareholders thought that why these 2 people are standing. They said that we want to propose these 2 people in a batch. Shareholders will accept or will not accept? Will accept. First they will accept the standing in a batch. Anyway, I want not to appoint B1. Anyway, I don't want to appoint B2. Let them stand in a batch. Now we will not pass a ordinary resolution in favor. One rejection will become 2 directors to leave the company. Did you understand the concept clearly? So the point is, first resolution is not at all appointment related. First resolution is what? Make the people to stand in a batch. That's all. For that, you require a unanimous approval of all the casted votes. Clear as everyone? Understood the idea of the section? So confusion will come in which case? Third case la confusion will come. G1, B1 standard. G1 is a good person. B1 is almost a bad person to the core for the company. Shareholders saw both of them. We want to appoint both of them in a batch. Batch means what? Batch means if you elect one, another will also come. అంటే ఇప్పుడు జీవన్ ఒప్పుకుంటే B1 కూడా వస్తాడు అన్నాడు. వస్తాడు అంటే B1 వద్దంటే జీవన్ వెళ్ళిపోతాడు అన్నాడు. ఓకే, వాట్ వీ హ్యావ్ టు డూ? ఫస్ట్ టెల్ యువర్ ప్రపోజల్. ఈజ్ ఇట్ ఓకే? ఈజ్ దిస్ బ్యాచ్ ఓకే ఫర్ యూ? That resolution will be passed with unanimity. Cannot pass? Cannot. Therefore, make them to stand independently. Clear or not, sir? Everyone? Clear or not, everyone? So, example, I have taken 2 directors. There can be 3, there can be 4, there can be 5 also. Sir, when this section is really useful? In case of private companies. That's why private companies, this section do not apply. You can have any number of appointments you want. Clear or not, everyone in the class? Sir, anyway, tell me, sir, what is the procedure you need to follow in order to appoint 2 or more directors by a single resolution? Directly can we put for appointment? First, which resolution we need to pass? Proposal resolution is a resolution for appointment or resolution to propose the batch up. Propose a batch, okay, to stand before the shareholders. Next, after that, which resolution we will pass? Appointment. Appointment resolution may be passed in favor. Appointment resolution may be passed against. If it passes in favor, multiple directors will come. If it pass against, multiple directors will go. Entire batch will come, entire batch will go. Clear or not, everyone in the class? Understood, everyone? And now listen carefully, the last point. there is a company. G1 and B1 are standing in a batch. Shareholders saw both of them. They couldn't understand what is going on. Chairperson said that we are proposing a batch appointment. Please vote for them. People saw G1 and B1. Are G1 is a great person here. B1 is a worst fellow to the core. But in the mind, subconscious mind, Indian democracy is always remembered by everyone. Okay. One bad fellow may be entertained, but one good person should not suffer. With that logic, what they have done, he's a great person. Let's not disappoint him. They voted for G1. Did you understand the point? Bachelor, they didn't propose the resolution. Directly they put it for appointment. Shareholders thought that maybe this is possible under Companies Act. Rather than they said that, let's vote for G1. Immediately they said that B1 also comes in. They thought that maybe this is possible under Companies Act. They also sat silent. Clear, everyone? Now, the point is, since no objection is raised in the general meeting, okay, since no objection is raised in the general meeting, okay, will this appointment become valid or not valid? No one raised objection for this batch. Objection not raised. Valid or not valid? Law has said very, very clearly. 15 minutes back, you people don't know that there is a concept like this. Then how come the shareholders attending the company general meeting will know there is Companies Act, in that there is section 162, their batch appointments are not possible. First we have to pass a proposal. After that we need to put it for appointment. Who will know? They thought that maybe this is possible. Their ignorance should be not taken as an advantage. Law is very clear to tell that. Second subsection. Read. Please read. A resolution moved in contravention of subsection 1 shall be valid or void, whether or not any objection was taken when it was moved. Whether you raise objections, whether you do not raise objection, that is irrelevant for decision making. If two directors are appointed by a single resolution without following the condition, their appointment is valid or void. It's a void appointment. So I hope everyone is having a clarity, right? Clear or not, everyone? So therefore their appointment will become valid or void appointment. It's a void appointment. Whether you raise objections, you may not raise objections, appointment will be rendered. So tell me, sir, summarize and tell me the answer. First, if you want to appoint the directors in a group, in a batch, what is the procedure? Step 1. Proposal resolution is a appointment resolution. Intention to make the people to stand in a batch. That must be passed as which approval? Without even single vote cast against it. After that, which resolution you will put? Appointment resolution. That will be a normal approval resolution. That means it may be ordinary, it may be special, depending on the directors they are standing. But one resolution will bring batch inside, or one failure will make batch to go out of the company. Clear or not? Objections are not raised by the shareholders. I contravene the provision. Appointment is valid or void. Whether they raise objections or not, contravention lead to the appointment to be made as a void appointment. Everyone clear to the point? Take a 5 minutes break and come. We'll continue. So let's continue. So settle down, please. Sir, everyone understood the concept clearly? Look. See here. Procedure to be followed. Step number 1. What is the resolution we need to pass? Proposal resolution. What is a proposal resolution? Proposal to appointment of 2 or more directors by a single resolution that shall be approved by all the members without any vote cast against it. That's called as a unanimity. And step number 2 will be which resolution? Appointment resolution. Appointment resolution depends. If it is ordinary, one ordinary will appoint both. If it is special, one special resolution will appoint both. Consequences of contravention. What will happen? Appointment made in contravention of this section shall be void irrespective of objections. Whether you raise objection or not, contravention of the section will make the appointment a void appointment. This is the idea. Everyone understood the concept clearly? Next, this particular section, there are some exemptions provided. Read. First one, read. In case of a private company, section 162 apply, will not apply, will not. Means in case of a private company, you can appoint any number of directors in a batch, because if at all wrong person comes in, only your family concern will suffer. Public interest not involved kada. Next one. In case of not all government company, which kind of government company? Let us see. A government company in which entire paid up share capital is held by central government or by state government or state governments or central government and one or more state government. Means it is a government company or wholly owned government company. Or next one, read a subsidiary of a government company referred to in A above, in which entire paid up share capital is held by that government company. Means it is a wholly owned subsidiary of wholly owned government company. So which government companies are exempted? Not applicable. Wholly owned government company, wholly owned subsidiary of wholly owned government company. That's all. Okay na? So see there, first one, non-applicability. Section 162 does not apply to which company? Private company. Government company, three types. First one, wholly owned government company, wholly owned subsidiary of such wholly owned government company, any other government company. So first case lo okay, second case lo okay, third case lo it will not apply. Means non-applicability will not apply. Means section will apply to those government companies. Clear everyone in the class? Note down them. Completed point A. Point A completed, huh? Consequences of contravention, non-applicability. Consequences of contravention, non-applicability. Completed? Completed? Sir, everyone completed, huh? Okay. So now we completed section number 162. Sir, everyone understood section number 162 clearly? Okay. How the questions are tested, that also just have a look on how the questions will be tested on that area. Take this question. May 2003 question. Read. Read. XYZ Company Limited in its annual general meeting appointed all its directors by passing one single resolution. They appointed. No objection was made to the resolution. Examine the validity of appointment of directors, explaining the relevant provisions of the Companies Act 2013. Next, will it make any difference if XYZ Company Limited were a private company? First answer, take XYZ Limited as a public company now. First we need to write the point of law. Okay. After that, conclusion. Read. In the given case, company appointed all its directors by passing one single resolution is legally invalid since procedure set out in 162 is not followed. Company XYZ Limited should have followed the procedure as below. Read. First one, pass a proposal resolution. Second one, proposal shows the intention to consider the appointment of two or more directors by a single resolution. Next one, that proposal shall be passed as a unanimous resolution. Next, unanimous resolution here represents a situation where all the shareholders who participated in voting shall absolutely vote in favor of intention to propose appointment of two or more directors by a single resolution. Situation analysis. Step 1 has obtained unanimity. Okay, if in that case unanimous approval is passed, two cases can come. Appointment may be approved by respect to resolution, appointment may not be approved. Sir, if unanimity accepts it, appointment accepted, batch accepted. Now if the resolution passed in favor, both will come. If resolution is passed against, both will leave the company. Clear, sir, everyone? Okay. Like this only the questions are tested. November 2010 also same question was asked with a difference, small difference is there. Like this the question came. Please read. In ABC Limited, 3 directors were to be appointed. The item was included in the agenda for AGM scheduled on 30th September 2014 under the category Ordinary Business. All the 3 persons as proposed by the board were elected by the board of directors by passing a single resolution avoiding repetition of resolution. ఇది ఓవర్ యాక్షన్. రిపిటేషన్ ఉందని రిపిటేషన్ని అవాయిడ్ చేయడానికి చేశాడట. బట్ అవాయిడ్ చేసింది రిపిటేషన్ కాదు, కంపెనీస్ యాక్ట్ని అవాయిడ్ చేసినట్టు ఇప్పుడు. సరే, ఎనీవే కంటిన్యూ. ఆఫ్టర్ ది 3 directors joined the board, certain members objected to their appointment and resolution. Examine the provisions of Companies Act 2013 and decide whether contention of the members shall be tenable and whether both appointment of directors and the single resolution passed at the company's annual general meeting shall be void. First tell me, it is valid or void? Procedure complied or not complied? Similar answer again. Okay. Next. May 2018 also question was tested. Read. Mr. Bond and Mr. James. చూసారా, ఇన్స్టిట్యూటెడ్ క్రియేటివిటీ పేర్లు అలానే ఉంటాయి. నేను ఇంకా ఆనెస్ట్ అని చెప్పి ఆపేమన్నా. వీడు చూడండి అసలు, వీడు ఇది పర్లా 2018 నవంబర్ ఎగ్జామ్ ఎఫ్ఆర్ పేపర్లో 2 కంపెనీ కన్సల్టేషన్ ఇచ్చాడు. నమో అండ్ రాగా లిమిటెడ్ అట. నమో అండ్ రాగా ఫైనల్ కూడా అడిగాడు అదే అటెంప్ట్. నమో లిమిటెడ్ అండ్ రాగా లిమిటెడ్. నమో అంటే నరేంద్ర మోడీ, రాగా అంటే రాహుల్ గాంధీ. మనోడు క్రియేటివిటీ మామూలుగా ఉండదు, మరి గట్ల ఉంటుంది మనతోని. అలా ఉంటుంది ఇన్స్టిట్యూట్తో. సో ఎంత క్రియేటివిటీ చూడండి. నమో అండ్ రాగా లిమిటెడ్ మెర్జ్డ్ ఇచ్చేదారట. సో నమో లిమిటెడ్, రాగా లిమిటెడ్. నమో అంటే నరేంద్ర మోడీ, రాగా అంటే రాహుల్ గాంధీ. అది గట్ల ఉంటుంది మనతోని. సో మిస్టర్ బాండ్ అండ్ మిస్టర్ జేమ్స్ were appointed as directors of James Bond Limited at the AGM held on 30th September 2017 by a single resolution. Okay. State relevant provisions of Companies Act 2013 identify is it possible to appoint about directors by a single resolution. This is again. Mali same answer we need to write for the answer. 2005 CS lo gada ade gets a question. Appointment of 2 or more directors can be made by single resolution only if before making such appointments an unanimous resolution is passed. Comment on the validity. Okay. Valid or not valid? Valid. Okay. I have one question. If at all I were to ask a question, ఎందుకు ఇలా అడగాలని ఉంది, ఇలా రకరకాలుగా. See here. Self-made illustrations. Sir, wherever possible I kept self-made illustrations. Worst case scenarios అన్నిటిని అనలైజ్ చేద్దామని. సో ఎగ్జామినేషన్లో దరిద్రం డిస్కోరెన్స్ ఆడితే ఇలా వస్తాయి క్వశ్చన్స్. సో జాగ్రత్త చూడండి. ఫస్ట్ కేస్, ఐ హ్యావ్ టేకెన్ వేరియస్ కేసెస్ యాజ్ ఎగ్జాంపుల్. లెట్ us చెక్ టు వాట్ ఎక్స్టెంట్ యూ అండర్స్టూడ్. టెల్ మీ. ఫస్ట్ కేస్ నెంబర్ 1. విచ్ కంపెనీ? ఏ లిమిటెడ్. పబ్లికా ప్రైవేటా? పబ్లిక్. ఓకే. టోటల్ నెంబర్ ఆఫ్ మెంబర్స్ ఆర్? మెంబర్స్ ప్రెసెంట్ ఆర్? మెంబర్స్ పార్టిసిపేట్ ఆర్? అప్రూవల్ రెజల్యూషన్ మీన్స్ ఫస్ట్ వన్ ప్రపోజల్. ఓకే. అప్రూవల్ రెజల్యూషన్ ఈజ్ అప్రూవ్డ్ బై 100. Tell me, in this case, unanimous approval obtained or not obtained? Answer, sir. Now see here. Appointment resolution, ordinary resolution. Appointment resolution, say for example, it is a ordinary resolution. Passed only one resolution. Valid or not valid? ఇదంతా క్వశ్చనే. ఇదే నేను హైడ్ చేయట్లా. సమ్ పీపుల్ ఆర్ థింకింగ్ దట్ హే హీ షోయింగ్ ఆన్సర్. అది కూడా అర్థం కాకపోతే ఇక అసలు ఏం చేయలేం మనం. అది క్వశ్చన్ అది. I just zoom that. కొంతమంది అనుకుంటున్నానేమో. Some people already thought that this is the answer. So read that. So tell me now, A limited lo there are 100, number of members present 100, members participating noting 100, approval made by 100, appointment as a ordinary resolution passed. Now tell me, appointments valid or not valid? Via IVA. Via. Okay, next. First అలానే ఉంటాయి ఇప్పుడు. Next, tell me, A limited, total number of members are? Number of members present are? Members participating noting are? Approval resolution approved by? Passed only one resolution. Valid or not valid? Valid or not valid? నిజంగానా? అదే మరి ప్రెసెంట్లో some people didn't participate కదా. Next one. Total number of members are? How many are present? How many participate in voting? How many approved the resolution? But they passed only one resolution. Appointment is valid or not valid? Valid or not? Valid or void? Void appointment. Next one. Company is public or private? Applicable or not applicable? Tell me now. How many are there? How many present? 80 how many vote? Present another present. Who? How many participated in voting? How many voted in favor? 60. Now tell me, disapproved by one resolution. Now tell me, valid procedure is valid or not valid? Absolutely valid procedure. ఇప్పుడు అర్థమైంది అసలు ఈ సెక్షన్ అర్థం చేసుకోవాలి. Once you pass a proposal resolution, anything can happen on appointment. Appointment lo, if one resolution is approving, both will come. If they disapprove, both will go. Both going outside is also valid resolution only. Okay. Next. A limited. How many total? 100 how many present? How many participated? 5 voted in favor. Okay. Now they pass a resolution, one single resolution. Valid or not valid? Valid or not valid? There is nothing said in the section that this many number of members must be there. Ekkada cheppala. Next. Enti? So ikkada chudandi sir. Totally how many members are there? 100. How many participate? How many present? How many participated? How many voted in favor? Valid or not valid? It is valid because it is a private limited company. Okay. This is also valid because this is which company? Next. X limited. Which company? Wholly owned government company. 190, 70, 60 passed one resolution. Valid or not valid? Valid or void? Chapali. Because this procedure is not required for them. Okay. Next. KMR Startup Foundation. Mande. Chappan sir. KMR Startup Foundation. Entadi? Foundations are always Section 8 companies. Okay. Read. 190, 70, 60 passed only one resolution. Valid or not valid? Section 8 company, did they give any exemption? Adi sir. Section 8 కంపెనీకి ఎగ్జామ్షన్ ఇచ్చింది ఇందాక సెక్షన్ నుంచి. కొంతమంది ఫ్లోలో వ్యాలిడ్ అంటున్నారు. వాళ్ళకి ఏ సెక్షన్తో పని లేదు. సెక్షన్ 8 అనగానే ఇన్వాలిడ్ వ్యాలిడ్ అనాలని అనుకుంటున్నారు వాళ్ళు. Section 8 companies, we have given exemption from which section? 149, not from 162. So, valid or void? Void. Next one. Y limited. Okay. In Y limited, X limited holds 60% of the paid up share capital. 180, 60, 50. అయినా కానీ చూసుకోవాలి ఒక్కసారి ఇక్కడ X limited which company? Wholly owned. But this is a wholly owned subsidiary or normal subsidiary? Section apply or will not apply? Will apply or will not apply? Section applies means procedure is valid or void? Next. Z limited. Which kind of company? X limited holds 100% PSC. Procedure applicable or not applicable? Not. Therefore, whatever you do will become valid. Next one. W limited. AP state government holds 70% PSC. 180, 60, 50. Valid or void? Why void here? It's not a wholly owned government company. Next one. K private limited. Subsidiary to A limited. Tell me. 180, 60, 50. Procedure applicable or not applicable? Are private limited company. A limited is a normal company, not a government company. Section applicable or not applicable? Applicable. Subsidiary to a public company will be a public company. గట్లుంటుంది మనతోని. నిజానికి నేను పైవన్నీ చెప్పదలుచుకోలే, లాస్ట్ డే నేను చెప్పదలుచుకుంది. Subsidiary to a public company is automatically a subsidiary. You will read in CA Inter also in consolidation. Subsidiary to a public company will be a public company. ఇలాంటిది ఇప్పటిదాకా క్వశ్చన్ ఒక్కడు కూడా అడగల, నాకు ఛాన్స్ వస్తే ఇది అడుగుతా. ఓకే. సో K private limited. Read. K private limited which is a subsidiary to A limited. A limited is a, even though K private limited is a private company by its articles, public company definition clearly defines that public company means a company which is having a minimum paid up share capital and which is not a private company, provided that any subsidiary to a public company shall be automatically deemed as a public company though it is a private company by its articles. ఇది బేర్ యాక్ట్లో చెప్పాడు. మీన్స్ దో ఇన్ ది ఆర్టికల్స్ ఆఫ్ అసోసియేషన్ యువర్ కంపెనీ ఈజ్ ఎ ప్రైవేట్ కంపెనీ, because of becoming a subsidiary to a public company, it shall be deemed as a public company. Deemed as a now tell me, which company originally it is, but it is a subsidiary to whom? Automatically it will be deemed as a. Therefore provisions of public company will only apply to them. Procedure didn't follow. Valid or void? Void. I have given the answers in the question bank clearly. With what intention I have given the answers. Okay, all the 12 questions I have given. See here, read. Section is నేను ఇన్స్టిట్యూట్ అట్లా చేయండి సార్, ఆన్సర్ రాస్తే గన్ షాట్ కోర్టుకి సబ్మిట్ చేస్తే ఎలా ఉంటుందో అంత క్లియర్గా రాసుకోండి ఆన్సర్స్. సో జాగ్రత్త చూడండి. రీడ్. సెక్షన్ ఈజ్ అప్లికబుల్ టు K Private Limited since what is the reason? It is a deemed public company. A subsidiary to a public company shall be deemed as a public company though it continues to be a private company by its articles. Read. Since all the members who participated in voting has not voted in favor of the proposal resolution, basic condition is not satisfied. Ordinary resolution passed is irrelevant. A resolution moved in contravention of the above said provision shall be void whether or not any objection was taken when it was moved. That's all. Answer completed. If at all a question comes, we need to write these 3 points and close. Everyone understood 162? All illustrations also we have done. Different kinds of illustrations. Everyone got the confidence on the topic. Everyone in the class. So now we have done with section number 162. In the learning objectives, take that, completed. First learning objective is 149. Next one, 162. 2 things are completed. What is the next one? 176. What we left in the boat powers area, that we need to cover. Let's read. Okay, so please see the section once. Next section is interconnected section. So please, one section was left out in the board meetings chapter, board meetings and board powers, 176, that we are going to cover now. See the screen once. Defects in appointment of the directors not to invalidate the actions taken. Defects in appointment of directors not to invalidate actions taken. Let us read. No act done by a person as a director shall be deemed to be invalid, notwithstanding that it was subsequently noticed that his appointment was invalid by a reason of any defect or disqualification, or had terminated by virtue of any provision contained in this act or in the articles of the company, provided that nothing in this section shall be deemed to give the validity to any act done by the director after his appointment has been noticed by the company to have been invalid or to have terminated. This is the Bail Act provision he asked. Read it first, we go into analysis. Read it, sir. 176. Completed? Completed, huh? So this section will be talking about validity of the acts of the directors. Validity of acts of directors. It will be talking about the validity of the acts of directors. To what extent their acts are valid? That will be answered using this question. So anyway, I will explain you the idea behind this. See here. Okay, see the screen once. Please see the screen once, everyone. Directors are appointed in violation of section 162. Violation of section 162. How many directors? 2 directors, A and B, appointed in violation of section 162 at stage number 1. I will give time for you to copy this. At the time you can do, because you have to write the answer as well. See here already it is there, na? Okay, see here, see the screen once. So in violation of 162, how many directors are appointed? 2 directors. That means what would have happened? What do you mean violation of 162? Without passing a proposal resolution, directly they put for appointment. Whether or not objections are right, these 2 persons are appointed by a single resolution. Clear, everyone? Now listen carefully, sir. Please listen. Once we complete this section, we'll take a full break. Okay, so after that we will again recontinue with the remaining concepts and close. First listen carefully. 15 minutes to 20 minutes it will take to complete. So listen carefully. So the point is very clear. Stage number 1, who is appointed? A and B are appointed. Under which section? 162. In compliance or in contravention? Valid appointment or void appointment? Very good. Next. But they didn't notice this defect. Who didn't notice? Company didn't notice this defect. Okay. For example, 0 days, 10 days, 20 days. 10th day, company noted the defect that has happened. This is actual date of vacation of directors. Actually, they vacated the company on 20th day. Question. See the question again. First, today A and B are appointed under section 162 in violation. But they didn't know that it is there in Companies Act. By mistake it was done. Adi by mistake, knowingly or unknowingly, keep it aside. Contravention is a contravention. Telis cheste okati, telik cheste oka consequence undadu kada. Whether you may have done knowingly or unknowingly, consequence is same. Appointment is valid or void? Void appointment, I am only telling you the answer. Okay, so see there. Question is not on validity or void of appointment. It is a void appointment. We don't, no doubt in that. Okay, so see the question. 162 section la A and B are appointed by one single resolution without a proposal, which is a contravention of 162. But they don't know that this is a defective appointment for 10 days. In this 10 days, they have done some acts worth rupees 10 crores in the from the bank account of the company. Clear, everyone in the class? Next, even after knowing the defect, they continued for further another 10 days. And there also they have acted certain things. Another 5 crores or 10 crores contract they signed. And on 20th day, on the pressure of the chairperson and other directors of the company, they left the company and went out. Now the question is, their appointment is valid or void? First tell me about this. Valid or void? Void. Now the question is, acts done between 1 and 2, 2 and 3, what is the validity? They are valid or void? నేను 2 స్టేజ్లు రాసా కాబట్టి ఇప్పుడు దానికి ఒక ఆన్సర్ దీనికి ఒక ఆన్సర్ చెప్పాలని మాత్రం డిసైడ్ అవ్వకండి. ఫస్ట్ పాయింట్, ఇవి పిచ్చి పిచ్చి ఐడియాలు అనమాట ఇవన్నీ. ఇప్పుడు 2 స్టేజ్లు రాస్తే 2కి ఒక్కొక్క ఆన్సర్ ఇద్దాం, దీంట్లోటి దాంట్లోటి. ఐఎమ్ ఆస్కింగ్ యూ, యూజ్ యువర్ కామన్ సెన్స్ అండ్ గివ్ ఎన్ ఆన్సర్. If no common sense is there, at least read the law and then give the answer. You read the section, right? Tell me now. Acts done in between 1 and 2 are, sir, first thing, appointment at the origin is a valid appointment or void appointment? Void appointment. So acts done between 1 2, acts done between 2 3, valid or not valid? That's what I am asking you. 1 2 మరి ఇంకెందుకు యాడ్ అవడానికే వాయిడ్ అయింది? అపాయింట్మెంట్ వాయిడ్ అయ్యేది యాడ్ అవడానికే? ఇంకెందుకు అందరూ అదే చేస్తారుగా, యాక్ట్స్ వైలేట్ అయితే అందరూ అదే చేస్తారుగా, ఎవ్రీవన్ విల్ డూ దాట్. Did you understand the point what I said now? If really it is valid, then why the hell section? Void persons doing acts are also validating. Then what is the purpose of law? Did you understand the point, everyone? So first, outsiders. ఎవరయ్యా రామ్ జట్మలాని అంత ఆలోచిస్తున్నాడు? అవుట్సైడర్స్ దాకా వెళ్ళిపోయి ఉన్న ఇన్సైడర్ని అడుగుదాం. ఫస్ట్ ఇద్దరు డైరెక్టర్లు ఉన్నారు, ఏ బి అపాయింటెడ్ బై ఏ కామన్ రెజల్యూషన్. ఫస్ట్ టెల్ అబౌట్ హిమ్, లేటర్ వి విల్ సీ వాట్ హ్యాపన్స్ టు అవుట్సైడర్స్. సో టెల్ మీ. Appointment valid or void? First tell me that. A person whose appointment is void, acts done by him will become valid or void. Appointment valid or void? Acts done by a person whose appointment is void, the acts will become valid. Void. Void. Ante kada? Therefore law also said it is void. Law also said it is void. But I deem that they are valid. Originally they are void. I deem that they are valid. Nowhere he used the word acts are validated. Clear? ఏమన్నాడు చదవండి ఒకసారి. No act done by a person as a director shall be deemed to be adi really it is not invalid, deemed not as invalid. That means in reality it is a void act only, because a void person doing some act will become which act? Void act. But your ignorance of the defect I want to give one chance. But for the ignorance of the defect I want to give one chance. Therefore at least till the date you don't know the defect, I will give a benefit of doubt. Therefore for that particular 10 days period, acts shall be valid, deemed valid. Valid, deemed valid. This deemed validity cannot be given for the acts done after the knowledge of the defect. That's the second point. అక్కడ కూడా చూడండి, అందుకే డీమ్డ్ అనే వర్డ్ యూజ్ చేశాడు. Deemed validity cannot be given once the defect is coming into the knowledge of the company. That's the idea. అసలు వ్యాలిడ్ అనే కాన్సెప్ట్ లేదు దీనికి. ఏమైనా ఉంటే ఏముంది? డీమ్డ్ వ్యాలిడిటీయే. దెర్ ఈజ్ నో కాన్సెప్ట్ ఆఫ్ వ్యాలిడిటీ. వ్యాలిడిటీ ఏంటంటే వాయిడ్ చేసేవాడికి. ఏ వాయిడ్ అపాయింట్మెంట్ కాంట్ క్రియేట్ ఎ వ్యాలిడ్ కాంట్రాక్ట్. బట్ బెనిఫిట్ ఆఫ్ డౌట్, మేబీ ignorance of company's act is there. Without knowing all these things you might have entered into some contracts. For that I want to give one benefit of doubt, and they said that acts done till that date shall be deemed as a valid. That's the idea. Okay, but if you observe, section starts on a negative note. Read ఏమన్నాడు? No act done by a person as a director shall be deemed to be invalid. So instead of writing like that, we can also write like this: act done by a person as a director shall be deemed to be valid. Like that also I can write or not, but they will not write. దానికి ఓ రీజన్ ఇచ్చింది. So why they will always write like that? Let me give you one small story. You can understand much better. Long ago, so long ago, hundreds, thousands of years back, there used to be one great saint in India with a name called as Shankaracharya. His logic is called as Advaitam. Everyone know that. Okay, heard that. Even though concept is ununderstandable to the humankind, but at least know that there is a word called as Advaitam. Right? Dvaitam means what? Two. Advaitam means what? Rendu kaadu. Nyayam, anyayam means what? Nyayam kaani anyayam. Ante kada? Dharmam, adharmam. Always represents a negative sound in Sanskrit. Same also we imported even by the Telugu language. So anyway, most of the languages are transcripted from the Sanskrit. Therefore, same logic is used. So if you observe clearly, the logic that he has with him is called as Advaitam. Advaitam means what? Not to. అదేంటి ఒకటని చెప్పచ్చుగా, ఒకటని చెప్పచ్చుగా, రెండు కాదేంటి? ఏకత్వం కెన్ బి యువర్ లాజిక్. మోస్ట్ ఆఫ్ ద కింగ్స్ అట్ ద టైమ్ ఆల్సో యూజ్ టు ఆస్క్ ద సేమ్ క్వశ్చన్. ఎవ్రీథింగ్ ఈజ్ ఓకే, బట్ వై యూ కాల్ ఇట్ యాజ్ అద్వైతం? యూ కెన్ కాల్ ఇట్ ఏకత్వం. సో అద్వైతం మీద రెండు ఏం నీ లాజిక్ ఏంటి అంటే రెండు కాదు అన్నాడు. అదేంటి ఒకటని చెప్పచ్చుగా, రెండు కాదేంటి? సో దేర్ ఫోర్ హీ వాజ్ ఆల్సో ఆస్క్ ద సేమ్ క్వశ్చన్, వై యూ ఆర్ టెల్లింగ్ ఆన్ ఎ నెగటివ్ నోట్? No act done by a director person as a director shall be deemed to be invalid. అలా రాసే బదులు act done by a person as a director shall be deemed as valid అని రాయొచ్చుగా. Why you are telling on a negative note? He simply gave a clarification saying that why Advaitam, why not Ekatvam? People always think that God is separate, He is separate. నేను వేరు, దేవుడు వేరు, నీలో ఉన్నాడనే విషయం మర్చిపోతావు. You forgot that God is there inside you. So you use it to see God as a separate entity from a human being. సపరేట్ కాదు అని చెప్పడం నా ఉద్దేశం, ఎందుకంటే నువ్వు సపరేట్ అనుకుంటున్నావు కాబట్టి. వాయిడ్ అపాయింట్మెంట్కి జనరల్లీ ఫర్ ఎ వాయిడ్ అపాయింట్మెంట్ యాక్ట్స్ విల్ బికమ్ వాయిడ్ అని నువ్వు అనుకుంటావు కాబట్టి వాయిడ్ కాదని చెప్పడం నా ఉద్దేశం. Did you understand the logic of the law? Generally void appointments will lead to acts being, I want to tell it is not void, therefore I started on a negative note. You think that God and mankind is different. No, He is within us. He is within us. So when you put some hard work, your brain is your God. So therefore He is there within us. So you are thinking that He is different from you. You are thinking that He is some eternal entity different from us. But He is there within. So you have to put some effort to bring Him outside. So therefore there is only one person. It's you. You are the one. అనేది నా ఉద్దేశం. కాబట్టి పీపుల్ ఆర్ థింకింగ్ దట్ దెర్ ఆర్ టూ డిఫరెంట్ పర్సన్స్. ఐ వాంట్ టు ప్రూవ్ దట్ టూ డిఫరెంట్ పర్సన్స్ ఆర్ నాట్ దేర్. దేర్ ఫోర్ మై లాజిక్ ఈజ్ రెండు కాదు. ఈవెన్ ఇన్ ది సేమ్ సెక్షన్ ఆల్సో హీస్ యూజింగ్ ద సేమ్ కైండ్ ఆఫ్ అద్వైతం లాజిక్. రీడ్ ద సెక్షన్. నో యాక్ట్ డన్ బై ఎ పర్సన్ యాజ్ ఏ షెల్ బి డీమ్డ్ యాజ్ means you can also tell act done by a person as a director shall be deemed as a valid. Yes or no, everyone? Now logic is very simple, sir. Hope you understood the logic, correct? Acts done between 2 to 3. Don't tell valid void. Deemed validity will be given or will not be given. Therefore see this. Read first. T0 A and B appointed by violating 162. Okay. T20 dates changed. Okay. So I can't remember the examples what I have written in the previous batch. So sir, 10 or 20, whatever the case may be. Read. Acts done in that 20 days will be valid, invalid, deemed as valid. Or you can write not deemed as invalid. Anything is correct. Okay. Next. T20. Company had the knowledge of irregularity. That appointment is a void ab initio. Even though it is void, up to then it is deemed as valid. Next, continue. T20 to 30 acts done are directly valid, deemed as valid, not deemed as valid. Because there is a negligence and element okati vachesindi akkada. What is the negligence element here? Even after knowing that there is a defect in your appointment, still you continued as a director, right? So therefore I don't want to give protection for the acts done after that date. Okay, for a T0 to for T20 to T30, outsiders should prove the doctrine of indoor management. For what? T20 to T30 contracts and transactions, outsiders should prove the doctrine of indoor management. What is the doctrine of indoor management? Now tell me about outsider. He has to read. He has to read. And he has to read. Understand the contents in a and no knowledge about, then outsider will be protected by the misdeeds inside the company. Clear, everyone in the class? This is what we said. Sir, everyone understood the logic clearly? So now, at the nutshell, when we complete entire section, tell me, no act done by a person as a director. Listening, everyone? Now answer my question, sir. In our example, you want to read the section, you can. No act done by a person as a director shall be deemed to be invalid. No act deemed to be invalid means what? Act is deemed as valid. Notwithstanding means ignoring that it was subsequently noticed that his appointment was invalid by reason of defect, disqualification, terminated by way of provision, etc. Provided that nothing in this section shall be deemed to give validity to what? Any act done by a director after his appointment has been noticed by the company to be invalid. That means after the notice of defect comes to you, after that any act done, deemed validity will be given or will not be given. That's the idea of the section. Everyone understood? Everyone understood? Now tell me, acts between T0 and T20, T10 or T20, whatever the case may be, valid, deemed valid. Tell me now, acts are done by whom in our example? In our example, acts are done by whom? Which two persons? A and B. Now answer my question, who are A and B? Who are A and B? They are persons, not a director. Because their appointment is void means how they become director. That's why section uses the word no act done by a person as a director. You are not a director. You are deeming that you are a director. Therefore, your acts are not valid. We deem that they are valid. Read the section. No act done by a director, no act done by a person as a director. That means you are a director, person, you are a person. Director appointment void untunte. We are telling that your appointment is void. From where directorship will come? You are not a director. You are deeming that you are a director. Therefore, your acts are not valid. We deem that they are valid. Read. No act done by a director, no act done by a person as a director. No act done by a person as a director shall be deemed to be invalid. Remaining section is same. Everyone understood the logic of the section? So see here. Defects in appointment not to invalidate the actions taken. Okay, analysis. Read. Validity of acts done before the knowledge of irregularity. Acts done by a person as a director shall be deemed to be valid. Next, validity of the acts after knowledge of irregularity. Acts done by a person after knowing that he is not a director shall not be deemed to be valid. This is an illustration. Clear everyone in the class? Clear everyone in the class? Understood? Okay. Considering illustration 1 above, examine the situation to an outsider who entered into a contract with the company through director A and B. Outsiders are protected by the doctrine of indoor management. So, hope everyone understood the section clearly. Write notes. Analysis, write down. Completed illustration 1. Completed illustrations. Completed. So let's close the class here. After the break, we will again recontinue. Next topic we are going to start is the consent 152 subsection number 5 and small concepts. 3-4 small sections are there. We'll complete those. Clear, everyone? Okay. So take a break and come soon. We will be starting with the consent concept after the break. Okay.